Hi, I'm attorney Ed Alexander, founder of the Entrepreneurship Law Firm. In this video, I'm going to talk about how securities laws affect your search for growth capital. There are basically two sets of securities laws. There are federal securities laws and state securities laws. Within each of these are two subsets, registration and anti-fraud. Registration laws require that before a company can sell stock, that it must register that stock with either the state securities administrator or the federal government, the SEC. That registration process requires the company to provide certain disclosures and to provide certain financial information, which generally is a very expensive process and requires the use of accountants and attorneys and costs hundreds of thousands of dollars. For small transactions, small businesses looking to raise capital, most of them do not go through this process. Instead, they rely on exemptions from registration to do what are called private placements. One of these exemptions is Regulation D, promulgated at the SEC at the federal level. Getting to the state securities laws, they're often known as blue sky laws. And some states have an interesting take on these. Instead of registration where there's adequate disclosure, some states require registration where there is a fairness opinion, where the state securities administrator will determine if the offering is fair to the investors. Now, each state has exemptions as well, and most of the states will have an exemption that tracks with what is Regulation D or Rule 504. I'll get to that in a minute. Anti-fraud is a key provision of both state and federal securities laws. The thing here is that fraud in the securities sense is not the fraud that you would think of. And generally, most people think of fraud as making a misstatement, and that is correct. But in the securities context, fraud can be not saying enough. It can be not identifying enough of the risks for your investors and having them come to you later on and say, if I'd have only known. So let's talk a little bit about Regulation D. Regulation D is what's known as a safe harbor, and it is comprised of several rules, Rule 501, 502, 504, 505, and 506. In Rule 501, it sets up a series of definitions. The most important definition you need to know is the definition of accredited investor. An accredited investor is a person who has a net worth of more than $1 million, excluding their personal residence or the equity in their home, but including the negative equity. So if they're upside down in their home, they have to include that as a negative against their net worth. It also includes an income test. So if the person has made $200,000 per year in each of the 2 prior years and expects to make that or more in this year, then they're an accredited investor. If they include income from their spouse, then that test goes to $300,000 or more. Thanks for watching this video. In our next video, I'm going to go further into Regulation D and Rule 504 offerings in particular.